So we jump forward to 1991, and we look at the next part, the other part of the Pregnancy Discrimination Act of 1978, and that is the part that excludes discrimination on the basis of pregnancy. So Johnson Controls manufactures batteries, which expose workers to a number of hazardous materials, but the one really important here is particularly lead. And so as a result, the company in question had a rule which prohibited women from working in jobs that might expose them to such hazards because of the potential that women might get pregnant and that would lead to unhealthy exposure to the fetus and complications and what have you. This exclusion did not apply to all women, but applied only to women capable of bearing children, which presumably meant women of childbearing years. So the court reviews this. It's a unanimous decision in which they say that, yeah, there's no question that this rule is barred by the Pregnancy Discrimination Act of 1978. And the reason why they say so is, well, let's be honest, fertile men but not fertile women are given a choice as to whether they wish to risk their reproductive health for a particular job. Because it turns out, by the way, that lead exposure in men can also lead to any number of defects of the fetus. So the company's fetal protection program explicitly discriminates against women on the basis of their sex, because it turns out that lead exposure to men also going to be bad. So this discrimination was absolutely a violation of the Pregnancy Discrimination Act of 1978. And the company, by the way, even knew that the exposure could be hazardous to men who also wanted to conceive, in fact, equally as hazardous. But the company made the choice where men could choose to take that risk, whereas women could not choose to take that risk. So the policy was declared illegal under the Pregnancy Discrimination Act of 1978. So because this law exists, and this is what really differentiates all of the earlier decisions, is that the Supreme Court doesn't have to weigh in on the constitutionality of the rule in question. It's because Congress has passed a law. Congress has given guidance. And the court, therefore, only has to look at the law and go, Pregnancy Discrimination Act of 1978. Does this rule discriminate on the basis of pregnancy? Yes, it does. Okay, then this rule can no longer be employed. The law controls in this situation. And because of that, and because of the guidance involved, there's a reason why this case is a unanimous decision, is because the court has guidance. The court has been told, in essence, what Congress believes, and whether the court agrees with it or not isn't really the question, because there's no constitutional issue at stake in this case. It's very clear that Congress has the authority to pass laws in this area. And so the only real question that comes up in this case is this rule a violation of the Pregnancy Discrimination Act? That's a pretty easy answer, as you can see from this case. Court says, yes, it is. And therefore, this rule in question has deprived these individuals of employment, and therefore, solutions must be made. Not an Equal Protection Clause case. We don't have to deal with we don't have to deal with levels of scrutiny. And what this case should show, though, in the confines of pregnancy discrimination, is when Congress has passed a law on something, when Congress has regulated something, it provides the court with a vast amount of information and guidance about how to rule in a particular area. In fact, it conditions what they do. In areas where there is no guidance, the court has to kind of make it up, and what you end up getting is what appears to be inconsistent and normatively bad decisions that, while legally correct, seem to go really against the tenor of society. So Congress, following a few of those decisions, passed the Pregnancy Discrimination Act of 1978. And now when the court considers issues in which pregnancy discrimination may have taken effect, they really only need to decide based on the statute itself if the rule in question is a violation of the Pregnancy Discrimination Act. They don't have to worry about the Equal Protection Clause. They don't have to worry about levels of judicial scrutiny and which one to use. So when Congress is making law, courts' jobs are easier.